Start. Exercise number 39, legal matter. The Mitakshara School of Law is one of the most important schools. Very wide jurisdiction. It applies to majority of India with slight variations with the fundamental principles being the same. These slight variations formed various sub-schools, namely Banaras School, Mithila School, Maharashtra/Bombay School, Dravida/Madras School. The drama Shastra or forensic law is to be found primarily in the institutes or collections known as Snihitas, Smritis, or in other words, the textbooks attributed to the learned scholarly sages such as Manu, Majnu Valchya, Vishnu Parasara, and Gautama, etc. Their writings are considered by the Hindus as authentic works. On these commentaries, digests, and annotations have been written. Stop, next para. Now, the very terms of the text refer to assets in which the whole estate of the deceased has been his separate property. And indeed, the whole chapter in which the text is contained seems to deal only with cases in which the property in question has been either wholly the common property of a united family or wholly the separate property of the deceased husband. We find no trace in it of a case like that before us, in which the property in question may have been in part the common property of a united family and in part the separate acquisition of the deceased. And it cannot, we think, be assumed that because widows take the whole estates of their husbands when they have been separated from and not subsequently reunited with their co-heirs and have died leaving male issue, they cannot, when their husbands have not been so separated, take any part of their estates, although it may have been their husband's separate acquisition. Stop, next para. The text therefore does not seem to us to govern this case, there being then no positive text governing the case before us. We must look to the principles of the law to guide us in determining it. It is to be observed in the first place that the general course of descent of separate property according to the Hindu law is no disputed. It is admitted that according to that law such property descends to widows in default of male issue. It is upon the respondent, therefore, to make out that the property here in question, which was separately acquired, does not descend according to the general course of the law. Stop, next para. The way in which this is attempted to be done is by showing a general state of co-paracenship as to the family property, but assuming this to have been proved or to be presumed from there being no disproof of the normal state of co-paracenship, this proof or absence of proof cannot alter the case unless it be also the law that there cannot be property belonging to a member of a united Hindu family which descends in a course different from that of the descent of a share of the property held in union. But such a proposition is new, unsupported by authority, and at variance with principle. Stop. Thank you.